Ready? 5 seconds. Start. In its recent decision in the Chief Information Commissioner versus High Court of Gujarat case, the Supreme Court regrettably barred citizens from securing access to court records under the Right to Information Act. Instead, the court held that such records can be accessed only through the rules laid down by each High Court under Article 225 of the Constitution. The Registry of the Supreme Court was litigating a similar case under bracket Registrar Supreme Court of India versus R.S. Misra bracket closed before the Delhi High Court for several years after the CIC had ordered it to provide copies of pleadings filed in a case under the RTI Act rather than insisting on litigants filing an application under the Supreme Court rules. Though the particular decision taken earlier this month does not preclude the application of the RTI Act to the administrative side of the court, it does firmly slam the door shut on accessing under the RTI Act the millions of court records filed on judicial side. Before explaining the faults and the consequences with this decision of the Supreme Court, it is necessary to understand the importance of court records to public discourse in India. A significant number of decisions taken by the courts influence our daily life. Every prosecution before a criminal court is essentially an opportunity to hold the police accountable, just as every writ petition is an opportunity to hold the government accountable. Similarly, a significant number of commercial lawsuits are opportunities to learn more about corporations and the manner in which commercial translations are executed in the country. In all these cases, the pleadings filed by either party contain reams of information that are useful to a range of stakeholders such as citizens, journalists, academics, shareholders, etc., who can better inform the public discourse on the ramifications of these decisions. This is especially true in cases of public interest litigation where the courts indulge in policy making on the basis of the report of an amicus curiae or an expert committee set up by judges. The reports of these committees are not accessible to third parties, though they may be impacted by these decisions because they form part of the court record and are hence outside the purview of the RTI Act. There is no question of arguing for the confidentiality of these records because it is by now a well recognized principle that all judicial proceedings must take place in open court unless prohibited by law for reasonable purposes. But while it is completely legal for anyone to sit in court and take notes while a lawyer narrates the content of pleadings, the court make it as difficult as possible to access the pleadings in a simple manner. that shed for those with deeper pockets. It is only a matter of paying out a bribe to get copies of pleadings informally. The Supreme Court verdict in this case hinged on Section 22 of the RTI Act, which states that the RTI Act shall override any other law to the extent that the latter is inconsistent with the former. The section states act to have an overriding effect. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in the one official secret act 1923 and any other law for the time being in force or in any instrument having effect by virtue of any law other than this act. Stop.